Well, welcome everybody to the call this morning. I appreciate you joining us. I'm Stacy Carter with Pathways Senior Care Advisors, and at Pathways, what we do is we try to help clients and their families find the right path to meet those goals. We equip the clients and the caregivers with information that they need to make the best decisions that they can, save time, save money, and feel less stressed when a challenge arises with something with their parent or themselves or whatever, so that they're not in that crisis situation. We started this series of coffee and conversations a couple weeks ago. Actually, this is our third one. If you missed the other two, you can get those on our social media pages or on our website. Good information to follow. And what this is basically in the 3 years that Pathways has been open, we have found out that there are many paths, so to speak, to what you want when you get to the age where you need this, whether it's assisted living, whether it's memory care, whether it's I want to stay in my home. There's all kinds of avenues to get you to that point. And we hope that you would get to us sooner so that we can direct you to our partners out in the community to help you, assist you with all of those things. So that's kind of our goal. And what I'm going to do now is I'm going to turn it over to Mary, and she's going to introduce our speaker for today on estate planning.
Thank you, Stacy. I'm Mary Coron. I'm also with Pathway Senior Care Advisors. If you were able to see the first session, you'll know that one of the things we talk about with Pathways and planning is that we take the team approach. We'd like to be the planning consultants, but we want other people at the table that are experts in the different areas. And today, we're going to be talking about estate planning and various aspects of what you need to do to plan for later stages in your life. And there are a lot of good lawyers in Bowling Green, but today we have with us a very good lawyer. Her name is Stephanie McGehee Shacklette. She's with the law firm Barry McGehee. And we're really pleased to have you with us today, Stephanie.
Well, thank you very much. I am very happy to be here. Again, as I was saying, I've got one partner, so we're a small firm. We do estate planning almost exclusively and probate matters. So I just appreciate the invitation. Look forward to talking with you all today.
Great. Well, let's start out with just what is estate planning?
Yeah, that's what I say I do, right, is estate planning. But most of my clients don't really know what estate planning is. They don't call me and say, I need to do my estate planning. They say I need a will. Most people don't really, when I say estate planning, they're like, I'm not rich, I'm not wealthy, I don't have an estate, I don't need estate planning, I just need a will, please. So my goal initially when I meet with my clients is to explain to them really what I do, what estate planning is. And it's having a will is an important part of that, sure, but it's not the whole picture. So when I'm meeting with my clients, I explain to them that they need to take some other things into consideration as well, such as, how are their properties, maybe a business, how will all of that be managed after you're gone or when you're incapacitated and unable to handle that business or those properties? How are your healthcare decisions going to be made? Who's going to be doing that for you? Who's going to be managing your finances? How is your family going to be taken care of? So we're talking about issues that don't just occur at death, but also issues that occur during our lifetime. And then, also getting people in here, I deal with people don't want to meet with a lawyer to do their estate planning. And the reasons why is, number one, is we don't like to have the discussions that I force people to have. I ask uncomfortable questions. We don't like to face our mortality. We don't want to face the fact that we may be disabled and not able to take care of things ourselves. So that's a big roadblock for a lot of people who coming to me. Another thing is that we all have family issues, and that's something people are like, oh, I've got these family issues. I'm like, I don't that's fine. Like, let's just get it out on the table. I've got family issues too. You know, we all do. And, you know, people just don't want to dig up, you know, dig into those issues and create family strife. But we've really got to do that. And then some people feel like it's just too complex and too costly. So I try to get them over that and tell them, hey, it's we can do this in chunks. You don't have to do it all at once. And, you know, we can break it down to where it fits within your budget. So I don't want people to be overwhelmed by that process or the fact that it's going to be too costly, because if we don't do anything, we're just kicking that can down the road. And if we keep kicking that can down the road until we've passed away or until we're disabled, then that's going to make it, number one, extremely difficult on our family, because all of a sudden they've got to deal with it, and we haven't put a plan in place. And secondly, if you don't do anything, then the state kicks in and they have a plan for you. There is a legal system in place. There's a bunch of default rules, and most of us are not going to be happy with whatever that system is.
Well, yeah, you know, it is. We face that with Pathways clients all the time, that they wait until something happens to force them to get care instead of planning ahead, for the very same reason you talked about. They don't like to think about that. And I understand that, and you do too. But the earlier people can plan for the kind of care they need, and also all the things you just talked about, the better. So what if someone does die without a will?
Yeah, well, like I said, it makes it more difficult for the family. And I want to kind of explain a little bit why that is. So when you pass away, there is an estate that's created, whether you did the work beforehand and created a will, or whether you did nothing. When you pass away, there's property that has to be administered and distributed, and there's debts that have to be paid. There's things that have to be done when you pass away. So an estate is created for you. In most cases, a close relative is going to go to the probate court in the county in which you lived, and they're going to file a petition to open up your estate and be appointed either an executor or administrator. So when you pass away with a will, it's called testate, T-E-S-T-A-T-E, and the person in charge of your estate is called an executor. When you pass away without a will, it's called intestacy or intestate, I-N-T-E-S-T-A-T-E. And the person who's in charge of your estate at that point is an administrator, right? So both of these people have the same job essentially, and that is to gather your assets, pay your debts, and then distribute the property to somebody, right? So in a will, we're going to dictate where that property goes. What if we don't have a will? That's the question. Where does the property go? And this is where I think a lot of people are really going to get surprised by what they find out the legal system does. So if you're married, a lot of people want all of their property to go to their spouse. And unless you write that in a will, that is not actually how your property goes in Kentucky. And these laws, I do want to mention, vary by state. So in Kentucky, there's a very strong preference to keep property. You know, we're thinking family farms and whatnot in the family bloodlines. So the surviving spouse is actually pretty far down the list. So if you have a spouse and you don't have a will, your spouse is going to get approximately 1/2 of your assets. All right, the other half is going to go to your family in a certain priority. So we've got, first, if you have children, that other 50% is going to go to your children. If you don't have children, then it's going to go back to your parents, assuming they're living. If your parents aren't living, then it goes to your siblings, okay? And if they're not living, it goes to their children, so your nieces and nephews. So all of these people take that other 50% before your spouse gets that other 50%. Then finally the spouse comes in, okay? So this is, generally speaking, really not the way people want their property to go. So that's one negative aspect of not having a will. Another one is if you have minor children. So if you do nothing and your children inherit maybe 50%, maybe all of your property, then they're going to, number one, get it outright at the age of 18, which is a lot younger than most of us are comfortable with, at least for me. I'm the mother of 2 teenage boys. And if, let's say that they're under the age of 18 and your spouse gets half, your children get half, that money that goes to your children, their portion of that is going to go into what's called a blocked account. So your spouse is not going to be able to use that money for children without a court order. It's a very restrictive means of doing it. Whereas if you have a will, we can really dictate who's in charge of that money and how they're going to handle it. Another problem with not having a will is if you have a business. If you don't have a successor in line who's somebody who's immediately going to take over that business, then we've got, what's going to happen to the business? I mean, it's probably going to at least temporarily halt operations until somebody can be appointed to, start to run and operate that business. And then the other issue, and this probably is one of the biggest issues that I as an attorney have to deal with in an intestate estate, is who's in charge. So the court uses, again, a priority scheme for this. So if you have a spouse, it's going to be the spouse. If you don't have a spouse, but you have children, it's going to be all of your children. What I deal with frequently is where I'm dealing with an older lady most of the time, and women tend to outlive men, I'm going to say, but not always. But I'm dealing with an older lady who isn't married, has no children, and the people who, she doesn't do a will, so the people in charge are her nieces and nephews, okay? All of them, not just one, all of them. And, she may be close to one, but not others. But that entire group of people are going to be put in charge of her estate, and she might not know them, they may not know her wishes, and we're going to have, quite a bit of issues with people having different feelings and thoughts. And I deal with this a lot with children as well. Children have different thoughts about their parents and, what they want to do. So I like to have one person named as the person in charge, although sometimes you can consider more. But those are, definitely a lot of the issues that happen when we don't have a plan in place.
Planning is just so important on so many different spectrums. And here's another one. I mean, what if somebody becomes disabled, Stephanie?
Yeah, that's another, and again, thinking about, an older lady who doesn't have a spouse, doesn't have children, who's going to take care of her? If she hasn't done anything and she becomes, mentally disabled, physically disabled, what happens? And this is something I know you all see a lot, and I see a lot too. And it's very difficult. We can become impaired at any point in our lives due to a number of things, accidents, and whatnot. But as we age, as we all get older, we're all more than likely going to have some physical or mental impairments. And if you're married, chances are extremely likely that at least one of you, if not both of you, are going to have some impairment as you continue to age. And if you become incapacitated, not able to handle things on your own, and you've done nothing to prepare for this in advance, there's not much that the legal system can do other than having someone come in and be appointed guardian. So what you'll see oftentimes is particularly for people who are living alone, that social services comes in or is called in at some point when somebody alerts the authorities that someone's not being properly cared for, not taking care of themselves, and family members are contacted. So obviously, a lot of times it's somebody that doesn't really know the incapacitated individual. And then a guardianship proceeding starts. So you have to go to the county attorney, Amy Milliken, her office here locally, and we start that petition. And the person has to, you have to swear and affirm that this person's not capable of taking care of themselves. Very difficult for close family members. The person has to be evaluated by a social worker and also by a medical doctor. There's a guardian appointed to represent their interests. And there's a trial. It used to be a jury trial, and it still can be a jury trial, although the law has changed recently, and we can now have bench trials, which is a trial before a judge. And there has to be a legal determination that this person's incompetent. And then someone has to be appointed guardian, and that person has a lot put on their shoulders all of a sudden. In addition to taking care of the person and handling their finances, they have to report to the court annually as to every bit of income that they received and every expense that they made on that person's behalf. And they also have to report on their care, their health care and how their living arrangements are. So it's expensive and it's difficult. And again, it's one of those situations where you as the incapacitated person may be taken care of by someone you don't really know, who doesn't really know you. Whereas if you put proper documents in place to begin with, you could have had some direction and some say in all of that.
Absolutely. And one thing we see frequently, even when there has been some planning done and there are documents in place, we'll have an adult child who sits in our office and says their parent has dementia, and it's too late to ask them what they really wanted and what they really, what they need, but you don't know what their wishes were in terms of what kind of care they wanted. So going the whole circle with the plan is important. So let's talk about what are the key estate planning documents that everyone needs.
Yes. Well, this is something that I go over with all of my clients, because again, as I was saying, most clients just are thinking about that will. They're really not thinking about these other documents. So this is really what I'm getting ready to go through here is something that I tell all of my clients. Okay, these are the documents you need. So the first one, of course, is that last will and testament. In that document, you get to name who's in charge of administering your estate. You can, identify who gets what property and how that's to be distributed. In some cases, we might want to set up a trust for minor children. I kind of talked about that a little bit earlier. That would be a good place. Or other dependents, and we might have someone with special needs that needs to be addressed as well. So we can put all of that stuff in the will. As part of this will process, I do want to bring to your attention that not all property that you own passes through the will. It really depends upon the nature of the asset, so what type of property is and how it's titled. So for example, the easiest example for me to give you of this is retirement plans, so like 401ks, IRAs. Those have designated beneficiaries on them. So they don't actually go through the will unless you've messed up and not named a designated beneficiary, which is a terrible idea. So if you don't know, go check right now and make sure you have individuals designated as your beneficiaries on those accounts, because those should not and generally do not go through the will. So part of that estate planning process is for me to gather all of this financial information and help you evaluate it so that we can determine how that property is going to pass and make sure the will and the assets that you own coordinate and those all of those assets pass the way that you want them to. So it's more than just preparing a will. It's really an evaluation of all of your assets. So I do like to bring that to people's attention, because they always wonder why I'm asking for all of their personal financial information. It's really, really key to the process of what I'm doing. All right, so the second document you need is a durable financial power of attorney. A durable power of attorney is a document that allows you to appoint someone, and this person's called your agent or your attorney in fact, to manage your property, your financial affairs, and to deal with any legal issues that you may have. So you can give your agent very broad powers, basically the power to do anything that you could do with your property in your own right, or you can limit it. You can give them limited powers. Generally, in estate planning practice, we're wanting to the extent you're comfortable, to give broad powers, because I'm trying to make sure that the agent that we name can really do everything for you. So as part of that discussion, we want to make sure that we really, really trust the person we're naming, because we're giving them substantial power over our property. Now, there's legal requirements they have to follow. They have to use due care to act for your benefit in accordance with the terms of the document and in accordance with the law. However, if somebody nonetheless spends your money for their own benefit, it's going to be very hard to get that money back. So we have to we're putting a lot of trust in that person. So we really have to be careful and evaluate whether or not we're picking the right people. But having that document really makes things simpler, because if we have this document, we probably don't have to go through that guardianship process later on. We don't have to have all of those court accountings and rules in place. And we don't have to go to the court order if we need to transfer property or sell real estate, because we're going to put those into the power of attorney document. So it's less having to go to court, which is generally a good thing. All right, so that's two. I've covered the will and the financial power of attorney. The next document you need, everybody needs, is a living will directive. This is sometimes called an advanced care directive. And a living will is a document that describes your wishes regarding life prolonging care if you lack decisional capacity and you are terminally ill or permanently unconscious. So what do those words mean? That's what my clients often ask me. So you suffer from a terminal condition if your treating physician and one other doctor agree that you suffer from an incurable and irreversible condition that will result with death in a relatively short period of time, and you are permanently unconscious if two doctors agree that your condition shows an absence of cerebral cortical function. All right, so that's kind of the standard, and we're really talking end of life decisions here. And I also want to emphasize that you also have to lack decisional capacity, where this document really doesn't come into play. And so once the doctors have determined that you have this medical condition, then they look at the document, and you can either direct that life prolonging care be withheld or withdrawn, or you can say, I want somebody to make that decision for me at the time, and you can appoint somebody who would deal with it when and if that issue arises for you. So that's an important document, it's a medical directive, but it's very limited in scope. So that leads me to the fourth one that you need, which is a durable healthcare power of attorney. And a healthcare power of attorney is kind of like a financial power of attorney, but it deals with medical care and healthcare decisions that you need to make. Obviously broader in scope than what that living will directive covers. It deals with end of life decisions. The durable healthcare power of attorney deals with a much broader set of decisions. And again, only if you don't have decisional capacity to make those decisions on your own. And again, that healthcare power of a document also helps you avoid that guardianship. So those are the four documents that everybody needs. I mean, some people need other documents, but those are the basic documents that I highly encourage every adult to have.
Well, but there's a thing called the living trust. Who needs those?
Yeah, a lot of people want to know about living trusts and what that is. And when everybody almost always asks me about trusts, they've heard something about them, but they don't really know what they are. So I want to tell you all a little bit about that. Most people either think that they've been told that everybody has to have a trust, or they've been told that trusts are complex and costly, just a way for an attorney to make money, don't bother with them, okay? And neither one's obviously the right answer. It's somewhere in between. Trust can be helpful in various situations. We've talked about some of them. So if you've got minor children, if you've got a disabled person, a person with special needs, you might need a trust. If you've got a business, you might want to create one for business management purposes. And people with very large estates, there's a number of techniques that they can use to minimize taxes. So what is a trust? So in a trust, you transfer all or part of your property to a trustee, okay? So a trustee can be you, it can be an individual, or it might be a bank with trust powers. And then that trustee manages your property that you've given to them with written instructions on, how to administer the trust, how to distribute that property to the beneficiaries. Okay, the beneficiaries are the people who benefit from the trust. So they get the benefit of the money that you put in that trust. In a living trust, you are usually the person who creates it, you are usually the trustee, and you are usually also the beneficiary of it. In some other types of trusts, you may not be the trustee or you may not be the beneficiary. It just depends upon the circumstances. There's tons and tons of trusts out there. And so it really takes an evaluation of your situation, your property, and whether or not a trust is appropriate. Some of the other advantages of trust, just briefly, you know, sometimes people want to avoid probate. You can do that. Sometimes people use them for privacy because probate is a public proceeding, and maybe people don't know, well, you know, want the whole world to know what they have and who they're giving their property to. Trust can help you avoid that. Trusts are great for managing your property. So if you are worried about who's going to manage your property as you get older, as you age, trusts are a great way to do that as well. But not everybody needs one. So you just really need to sit down with your attorney, describe their situation, describe your situation, and they'll help you decide if you need one or not.
Okay, and I guess another thing I'm thinking about here, Stephanie, is should I be concerned about taxes after I die?
Yeah, that's a good question. A lot of people are worried about what's going to be the tax ramifications when I die. What are the death taxes? You know, you hear that in the media, that term death taxes a lot. Well, you know, they're like, what is that? So there isn't actually a quote death tax. Death taxes is just a, you know, a common word that's used to describe a number of types of taxes that are sometimes incurred when someone passes away. The two biggest ones are the inheritance tax and the estate tax. So when we're talking about the inheritance tax, that's a state tax. So Kentucky does, not all states have them, but Kentucky does have an inheritance tax. Whether or not it's going to apply to you depends upon who you're leaving your property to. So Kentucky taxes based upon the relationship of the donor of the gift, all right? So if you're leaving property to someone you're closely related to, they're probably exempt from Kentucky inheritance tax. So for example, if you're leaving it to your spouse or your children, your grandchildren, your parents, your siblings, probably don't have to worry about Kentucky inheritance tax. If you're leaving your property to nieces and nephews, or somebody that you're completely not related to at all, then there's going to be some Kentucky inheritance tax. So the further the relationship, the more the tax is going to be. The other tax that people are worried about is a federal estate tax. And for most of us right now, that's not a concern. The reason why is that the estate tax exemption is extremely high right now. Each individual has an exemption of $11.58 million for 2020, and that's going to keep going up a little bit through 2025. And I'm going to put a little asterisk right there next to that, all the way up to 2025, because that may not be the case. But let's just assume nothing changes and we each have this $11.58 million exemption. If we're married, guess what? We get to double it. So then we get to shelter $23 million and change before we have to worry about estate taxes. For the large majority of people, federal estate taxes is simply not an issue. Now, all of this is subject to change, right? So the way the law currently reads is January 1, 2026, our exemptions are going to go back down to 5 million, but indexed for inflation. So that's going to hit more people. And so a greater concern for estate planners, this is all the, you know, what we're talking about right now, is that we don't think that's going to last, right? We don't think that the current law is going to last, because the federal government has spent trillions upon trillions of dollars in stimulus packages, and they're talking about another one as we speak. And we've got an upcoming election. So most people think that that's going to change sooner than 2026. Some proposals would drop that exemption amount down to $3.5 million per person. So at that point, yeah, we're going to have some people who might need to do some estate tax planning as part of their estate planning. But for most, you know, so I guess the answer is it depends.
Yeah, and you know, estate planning, I think that brings to mind, I mean, I've had my estate plan reviewed 3 times in my lifetime because things have changed. So it's an ongoing, you need to do ongoing updates with your attorney as well, because as you say, things do change, not just taxes. Okay, I made an appointment. I called your office, Stephanie. I made an appointment to come and see you about either a document or an estate plan. What do I need to do to prepare for that meeting with you? What documents do I need to bring? What information do I need to bring to the meeting?
Well, making that call is a great first step. That's really the hardest part. But then it's like, what do I do to get ready for it? And I think putting some thought into some matters is going to help you a lot, because a lawyer is going to ask you a lot of personal questions and expect answers, because we really can't do anything until you've thought through these things. So doing some advanced thinking, think about what your goals are. How do you want to be cared for if you're disabled? Do you have long-term care insurance? Do you want to stay in home? Who's going to be your caregiver? Who's going to be your alternate caregiver? Think about those things. Who's going to take care of your spouse if you have minor children or children with special needs? How are they going to be taken care of? If you have a business, what's your plan? Do you have somebody who's going to buy it? Are you going to try to pass it on to your family? Are you going to liquidate it and sell it? What's your business succession plan? Do you have any ideas about charity? Is there a charity that you might want to benefit at your death? Or maybe you want to start initiating some lifetime giving to a charity. All of those are questions that they're going to be asking you. The second thing that we're going to delve into is your assets. So, I'm going to want to know what assets you have, how all of those assets are titled. I'm going to ask about the value of those assets. I'm going to ask if there's beneficiaries, designated beneficiaries of retirement plans, insurance. I'm really going to delve deep. So if you can start pulling out your deeds, your titles to your cars, your retirement plans, and a recent account statement for your retirement plans, same thing for your life insurance, the actual policy document, any current statements, investment accounts, checking accounts, pull it all together and put it in a binder. That's not only good for you, so that you can see what you have and double check all of your beneficiaries that you've probably forgotten about, but it will really help your attorney. Now, I have a questionnaire. So once my clients set up an appointment with me, we send them a questionnaire that they bring to the appointment. So that and I have even more in-depth questions that really helps people get their minds going and thinking about what I'm going to ask, so that they come prepared, because I really want that first meeting to be productive, because the less time, that I'm dealing with it, obviously it's cheaper for my clients. So the more thought you put into it, the cheaper your estate plan is going to be. So, and once you've met with your attorney, then they'll help you develop a plan, and it might be staged. I always tell my clients to do at least one thing. If you can't do it all right now, that's okay. Do at least one of the things we've talked about. And then once you've done that one thing, the next thing will be a little bit easier, and the next piece will be a little bit easier. And then also, as you mentioned, I let my clients know that, hey, all of this stuff we just created for you, it's a work in progress. You're probably going to want to change it in a few years, because as your life change, as laws change, we need to reevaluate these documents and we need to change them. They're not something you can just shove away in a drawer and say, yay, I did it. You got to stay on top of it. So just a few things that I tell my clients that I hope you all can take with you and use in your life and in your jobs as well.
Thank you. Reflecting on that, one place that in that process of planning for that meeting, that Pathways can be a great help to you, is helping you know what the care options are. So many people come to us and so many people say, I want to stay at home. And I get that. I'm at that age that I'm trying my best to remain independent and stay in my home. But sometimes that's not the best option for you. And the other thing that people don't really understand is the cost of care. You mentioned long-term care insurance, and that's certainly helps a lot. But I think a lot of our clients that come to us, when we sit down and start talking about the options that they have and how much they cost, that's usually a surprise to them. So, but Pathways will be glad to sit down with you as you plan for that meeting to meet with your attorney.
And
Stephanie, thank you so much. And does anybody have any questions?
You're muted.
Unmute yourself, Robin.
There we go. Okay, hi. If you have a trust from a different state done years ago, and then you do some of these, the four things that you're talking about, you do them here subsequently, do the newer things supersede the trust, or how do you revoke the trust?
Yeah, not necessarily. So let's say, you've got a trust. This happens a lot. You've got a trust that you did in another state. You moved to Kentucky. The number one question is it valid in Kentucky? And the answer is usually yes, because states will if it was validly created in the estate in which you created it, then Kentucky's going to recognize it. So even though you've done all of these documents, unless those documents specifically revoke that trust, then that is probably still a good trust. So it's actually fairly simple to revoke. Well, it depends on the type of trust. If it's a revocable living trust, the most common type that people have, it's actually fairly easy to revoke it. You just really need to, sign a piece of paper that says I revoke this trust. Now, I wouldn't just do that without consulting with somebody, because there's a lot of questions. Did you transfer assets to that trust? Does it own anything? So if you did, we don't want to just revoke it. We want to get those assets out of that trust, just to clean it all up and so we don't have any issues later.
So if what somebody needed help with was to remove the house that was in the trust and take it out of the trust and pass it back to the person, is that something that you do, and is that expensive to do?
It really depends. So if it's in a revocable living trust, that, like I said, that most common trust, then it's really not that difficult. What it takes is having somebody review the trust document to make sure that asset can come back out, because sometimes we put them in there with the idea we're not going to pull them back out. So we have to see if it's possible, so that we follow it properly. And then it just requires, assuming you can, it just requires a deed signed by you to yourself or whomever to get it out. So it's not that costly, but it's a couple meetings with a lawyer and review and preparing the deed.
Do you charge for consultations so that you know how much the eventual cost would be? Like, that you sit down together and you say, okay, in the end, I'm going to need a new trust, or I'm going to need my trust revoked. How do you, before you sit down, how do you know what that's going to be?
Yeah, I usually do. Now, not all attorneys charge for initial consultations. I usually do, because I'm usually having I'm giving away legal advice and having a true consult. So I usually charge for that. And then at that meeting, I will, kind of come up with the plan, if I can, right there on the spot, and tell them what the range, what I expect the range to be, depending on what my client's individual circumstances are.
Okay.
Okay, great questions. Anybody else?
Stephanie,
Yes.
can you speak to the complications with the blended family in estate planning and some of the things that can really, really go wrong if they don't address them?
Yes. Okay. There's, so many things that can go wrong there. Number one, when you've got people, two individuals come together who both have children from other marriages, if you give all of your property to your spouse, which most people want to do, then the surviving spouse dictates the control of those assets after your death. So in most cases, I'm going to say not all, but in most cases, that property is probably going to end up to your spouse's children and not yours. So that is one of those situations where I do encourage clients to get a trust so that you can set up those assets in trust for your spouse. But when your spouse passes away, you dictate where that property goes, so you don't lose that control. So that's just one of the messy ways that blended families, and again, that issue of who's in charge and the, you can imagine the conflict that emerges when, especially both of those individuals are gone, and you've got these children from separate families. with different goals and different thoughts in mind. Yep. So all the more reason to have those documents in place to say, this is who's in charge, and this is how the property is going to go.
Thank you. And another thing that made me think about is when someone predeceases, like my mother died before my grandmother died. And so when grandmother passes, it was not written correctly. And so I'm one of 5 children that got left out of that.
Yeah, that I see that so often. So what happens, and I don't even know how to stop this. It's unfortunate, but when let's say that there's grandma and there's several children, and then when one of those children die, sometimes and I don't know if it's undue influence or so you've got to watch that. The older people you've got to watch taking them in to get wills drawn up. That's on me. You know, I've got to really make sure that these people want to do what they're doing and know what they're doing, and they're not being unduly influenced. But you will see people get cut out. You know, well, that person died, them and all of their heirs, because they passed away, and then it gets redistributed to the other living children. That is incredibly common.
Thanks.
I have another question.
Mm-hmm.
If I have like some of those documents drawn up with you, and then down the line, I want to change something in it. Somebody passes away and I want to change a name. Is it as simple as where I can initial it and have it notarized, or do I have to have a new document drawn up?
You need to come back to the attorney or an attorney and do that properly, because wills, generally speaking, have very stringent execution requirements. So they've got to be signed by you and 2 witnesses and a notary. And so you want to make sure it's done right. Just, signing it and initialing it, notarizing it probably isn't going to cut it. So there's 2 ways to change a will. One is by codicil, which means you've got this will, and then you do a codicil, which changes the terms of the will. So when somebody dies, they take both of those documents. They take the will and the codicil, which is essentially an amendment. Sometimes people, they make a change that they don't want the whole world to know about. So that requires us to do a whole new will other than a codicil. So it really depends upon the type of change that you're wanting to make. You know, if it's a fairly small change, sometimes an amendment, a codicil will work, and that's less money, obviously. Sometimes it's a pretty substantial change, and we just have to start from scratch, and that's more expensive, and that's just how it is.
Now, if your family member can't find your will, but they know who your attorney is, are they kept on file with the attorney's office so they can just go there and get the copy?
Hopefully. I mean, I keep copies of my clients' wills. I'll also indicate who is supposed to be maintaining the original, whether it's my office or somebody else. I like to have a note of that. But I'm not, that's my practice. Hopefully others have similar practices, but they might not. That's a good question to ask the attorney when you meet with them.
Okay.
Okay, any other questions? Well, these were great questions. Again, you've been hearing Stephanie McGehee Shacklette with Barry McGehee Law Firm here in Bowling Green. Thank you so much, Stephanie, for presenting today. Pathways Senior Care Advisors really appreciates you taking the time, and I've learned a lot, and I hope everybody listening to this presentation has. Thank you very much.
Thank you for having me.
Thank you.
Thank you very much. Thank you.
Bye-bye.
Goodbye.